It is not over until all the attorneys in the room agree that it is over. They have to tell the court reporter that they are now off the record. You cannot relax until that moment. When you hear attorneys say, "That's all I have," you might think that the deposition is over. It rarely is at that point. Any of the other attorneys in the room can still ask additional questions. Even the first attorney, who said he had no more questions, can come back later and ask you additional ones. Remember that the deposition is a discovery process. Every time you answer a question, your answer may contain additional content that may lead an opposing attorney to ask further questions. So your expert report is not the only fodder for questioning. It is only the beginning. Every one of your answers, especially if you give any contradictory or conflicting responses, may produce a bevy of new questions. So do not take that proverbial deep breath and relax until it is off the record and the deposition really ends. Depending on the urgency of the case, the attorneys may press the court reporter for copies of the transcript immediately. They may even ask for an electronic raw copy of the deposition. The term raw refers to a copy of exactly what the court reporter has typed during the deposition day or days. Generally, court reporters do edit their own typing before submitting it for review to the expert who is deposed. While the court reporter attempts to correct obviously mistaken spelling or grammatical errors, he cannot correct technical misunderstandings on his part regarding your content. That is your job during your review. Remember, the court reporter's typed record is a legal document. It assumes even more legal import when, as you will be asked to do, you sign that the transcript is a valid reflection of what you said during the deposition. After the deposition ends, you should read the transcript you are provided by the court reporter and submit any corrections. Your corrections will be incorporated into the transcript as the final, confirmed transcript. You may not change your way of thinking or change any details of opinions that you expressed while you are reviewing. You are only correcting the court reporter's obvious misunderstandings of individual words you spoke when you said them during the deposition. If the court reporter thinks he heard something and you know that you did not say the words he typed, you have to catch that. Otherwise, if it is a particularly important phrase regarding your work, you will have allowed a conflict to remain in the record, and you will surely have to explain that seeming conflict later at a trial. Do not put yourself in that potentially embarrassing predicament. Simply spend the necessary time to reread your own transcript and edit any errors before they are cast in stone. And an important tactic to keep in mind is that you should not allow your own attorney to waive your right to read, review, and possibly correct the deposition transcript. Confidentiality before, during, and after the deposition is another issue that we should consider briefly. In many legal matters, you will have to sign a confidentiality agreement before you even begin work on the case, and before you ever see your first piece of evidence to review. That confidentiality agreement binds you from revealing anything that you learn in the case. Generally, they do not want you to reveal private details to the public. This could be during as well as after the case. If information becomes public later, perhaps revealed as the result of a trial, then those facts are obviously no longer unknown. However, it is both ethically and legally prudent to refrain from discussing the details of your cases with others in the public, such as colleagues or friends or students. Even after the case is over, you generally want to be circumspect and guarded about the details of any case. Many of your cases will settle for undisclosed reasons and under unrevealed terms. you played an important role in leading to that kind of settlement. The information you discovered, learned, or concluded may be an important reason for the agreement and the settlement by the litigants. Especially in cases where a settlement is reached in which the terms are not to be revealed, you should keep everything you know about the case to yourself.